want to follow up on your discussion with Senators Feinstein about Roe v. Casey and your conversation with Senator Durbin about Garza, and also raised by my colleague, Senator Blumenthal. You talked about the importance of precedents. You said you understand the strong feelings about abortion. You said you recognize the real-world effect of cases and you don't live in a bubble. But I think when you talk about respect for precedent, it's misleading, because there are ways to say you are relying on precedent, i.e. Roe and Roe v. Wade and his progeny, but still severely limit a woman's right to make her own reproductive choices. And that is exactly what you did in Garza. Because we all recognize that even if Roe v. Wade is not overturned, there are going to be many cases that will continue to come before all of the courts, including the Supreme Court, that will probably be laws enacted by states that will limit a woman's right to choose. So, including things like parental consent, spousal consent or notification, limits on where abortions can be performed, i.e. whole women. So both Senators Durbin and Blumenthal explained the facts in Garza, so I won't go over that, but when the case reached you, you took any opportunity you could to prevent that girl from getting an abortion. You said you were relying on precedent, but you weren't. You turned this case into a parental consent case, which it wasn't. Then you looked at the facts and ruled against, in my view, all common sense, that keeping a young woman behind lock and key against her will by ORR, Office of Refugee Relocation, insisting that ORR be allowed to delay beyond the time abortion would no longer be feasible by finding her sponsors that she did not need, and that you deemed these factual circumstances not an undue burden on her constitutional right for an abortion. Let me read you a portion of your dissent in this case. You say the majority points out in states such as Texas, the minor will have received a judicial bypass. That is true, but is irrelevant to the current situation. Why? The current situation was all about parental consent and the need to get judicial bypass, which this young woman did. So if there's anything that's irrelevant, is your argument that this was a parental consent case. Then you went on to analyze this case on the basis of whether or not keeping her under lock and key, insisting that there be sponsors found for her, which could have ended up being an unfeasible time frame for her to get an abortion, and you deemed those not to be undue burdens. The young woman had already received a state judicial bypass, as referenced before. The fact that she did not have, you thought that parental consent, that was not even an issue. It was irrelevant. So this is very disturbing. Is it any wonder there are so many people who, even if you are not sitting there, in spite of the fact that President Trump said his nominees to the Supreme Court will overturn Roe v. Wade, even if Roe is not overturned, there will be, as I mentioned, all of these cases that will put barriers before a woman's right to choose. So I find it really a rather unbelievable. And by the way, you also mentioned, you said several times that in Garza you did not join the dissent, which basically says an alien minor does not have a constitutional right to an abortion. So does the fact that you didn't join this dissent mean that undocumented persons do have a constitutional right to an abortion?
Well, I decided that case based on the precedent of the Supreme Court and the arguments that were presented in the case. I made clear that I was following as carefully as I could the precedent. You mentioned parental consent and spousal consent. Just the Supreme Court has upheld parental consent laws, but has rejected spousal consent.
Usually it requires a judicial waiver, which was the case in the Texas case. You can't just require parental consent, as in this case where parents were beating her up. How can you expect parental consent in a situation like that?
That would be a situation for the bypass. This was an analogy for a woman who was a minor, that's critical, who was in a immigration facility by herself in the United States, and had.
She had already gotten a judicial bypass. There was no issue of parental consent, and in this case, you would have substituted a foster family for parental consent. That's not even an issue. But I do have a question, since you mentioned several times that you did not join the dissent, and the crux of the dissent was that there was no constitutional right for an alien minor to have an abortion. I want to ask you, did you join or did you not join that consent because you disagree with that in fact, alien minors do have a right to an abortion in our country?
Well, so as a general proposition, well, first of all, the government did not argue in that case that aliens lack constitutional right generally to obtain an abortion.
Yeah, even they didn't argue it because probably they figured that that is a decided issue, but maybe you don't think so. Do you think that that is an open question as to whether or not alien minors, or in fact aliens in our country, have a constitutional right to an abortion? Do you think that is an open case?
The Supreme Court has recognized that persons in the United States have constitutional rights